Hi. Hello. Good job, everyone. My name is Shannon Shinsky. I'm an attorney. The firm that I work for is called Kilpatrick and Associates, PC. My primary practice area is bankruptcy, but I also practice in commercial litigation and just general business law, incorporating businesses and creating business and stuff. I'm primarily also in the bankruptcy area. I'm a creditor's attorney. So I'm sure that you've heard about the little case called the City of Detroit. I represent the Detroit Water and Sewerage Department. The last trial that I was involved in was related to the water shutoffs. So the human rights trial that just occurred, that I was counsel for the Water and Sewerage Department in that trial, along with Miller Canfield and other brilliant attorneys. It was not just me. I've known this gentleman here since we were in mock trial together in undergrad. I've been practicing for 5 years.
I'm Evan Shaw. I am also an attorney, as Shannon said, former mock trialer. I work for a firm called Wright Beamer PLC in Farmington Hills, practice primarily in the area of business litigation, employment law. Actually had my first real trials this January. So I got to see what it's really like in the courtroom in front of the judge.
I've been trying cases since he was an infant.
So right. Keep telling yourself that. All yours are very important. Oh, City of Detroit stuff. I have my little district court cases. I don't want to hold you guys up too much. I think both sides did a nice job considering how early we are in the season. I think showed professionalism, which is great. It's surprising to see how unprofessional some actual real attorneys can be in court. So fortunately no one fell into the sort of unprofessional category that I've seen where people, I saw somebody bring up their huge mega size Starbucks coffee up to the lectern speaking before the judge. The judge was like, hey, what's going on with this? Like, show some respect for the judicial process. So that's great. I think substance wise, there's certainly some room for improvement as you progress with the season. I'd like to see both teams really work on getting a clear theme that you can go back to. This side needs to work on developing a theme. This side had that theme related to the parents, but I think that theme can easily be used against you as well. I mean, a theme is important when you're in a real life trial, but I think for purposes of mock trial, it's even more important. It can rise to the level of cheesy or just sort of over the top. But I think you have to definitely work on that, and hopefully that should be woven into your opening, and then brought back to the close. So I didn't see it much in the opening, but then I saw it in the closing argument. And certainly in closing, you got to make sure that all the evidence is, try to tie it together as much as possible. That's really a challenge, and make sure that you only reference testimony and evidence that was actually introduced in the trial. In a couple instances we saw, I think, reference to facts that were not in evidence, and that's a big no. And it may be, oh my gosh, you could say, oh my gosh, no, we did hear something about that. Well, if we did, I didn't catch it. So you need to highlight it even more, accentuate it to make sure that we know that was actually in there. Just a couple more comments, and we'll turn over to Shannon. I think in general, make sure that you're lodging the objections. If you don't, you don't have the opportunity to do sort of what mock trial is designed to do in part, which is be able to argue the rules of evidence here, our wonderful Midland rules of evidence. If you're not making the objections, you don't have that chance. You may say, oh my gosh, well, I'll get overruled on that objection. Yeah, it's here, I'll say it's objection, Your Honor, hearsay, but well, it gets in because it's subject to the party opponent rule, or well, it's maybe a business record.
They might not know that.
You're right, make them say that. So everybody, I think almost across the board, universally here, not making enough objections, and if nothing else, just break things up. You've got to break. It's a chance for you to interrupt them and maybe get them off track. So do that. So those are really my comments. Yes, and I'd like to live dangerously.
Yeah, right. So initially, the first thing that I noticed that no one mentioned how old the kids were, like in their opening statements or anything. So we're kind of going into it like, okay, so kids shot each other. They could have been 5, they could have been 14. We didn't really know. I don't recall anybody really mentioning, you know, Sydney's 11 and Jesse's 11 or, you know, whatever, like kind of came out later. So I think it's kind of good maybe at the outset. There was just, in general, there was kind of like a lack of describing like who the people were and like, you know, identifying them and everything in the opening for both sides, I think. So what was going on like with the expert witness stuff? Because like, do you guys not have to ask the court to have somebody qualified as an expert witness? I mean, you just ask the foundational questions and that's it? Because I mean, how does the other side have the opportunity to object to somebody being qualified or doing a voir dire or something like that related to the witness?
Mock trial doesn't have a voir dire hearing. That's open for cross-examination.
Right, that's
why we try to establish
Well,
it.
they allow you to voir dire witnesses in my trial. They don't say, okay, this is expert witnesses. They just ask certain questions like, are you qualified?
Right, but what I'm saying is, okay, so we have, you know, the doctor or whatever. I mean, obviously, all the foundational questions were asked. So after you asked those foundational questions, if it was me and this was my expert, I would have said, Your Honor, I would now like to qualify this witness as an expert.
Yeah, that's right.
Then I'd say, do you have any objection? Oh, okay. Then we're moving on. Or they could say, I would like to voir dire. I mean, I don't even know if that's possible here, but I mean.
You can,
Yeah, it is. I'm sorry, I meant
voir
Dover
dire.
hearings.
Okay.
You can voir dire.
Yeah,
You don't have to ask
as
that.
far as I knew, I thought I was just assumed after you asked all the foundation questions that they were an expert. But as far as
Well, you have to
Voltaire,
remember the
that's-
people who are typically going to be judging these are probably going to be like attorneys and judges, so that's what we're used to seeing. So for us, we were like, is this person an expert? Is this person not an expert? We don't really know what's going on. Also, I thought it was a little strange that the forensic person wasn't qualified, because you guys didn't do the foundational stuff to qualify her as an expert. You were really close, but it didn't happen. So, I mean, I don't know if that's just like a theory of your case, or you just don't think it's necessary, that's fine, but I mean, she has all the qualifications, so why not? You know, I mean, unless there's some sort of downside that I'm not aware of. I think that it's probably a good practice to introduce yourself every time before you do it. You know, I'm, you know, Shanna Kaminsky for the plaintiff. You know, may I proceed? I know it was happening sometimes it wasn't, but like if you were in court for real, which is what I'm assuming all of you are trying to prepare for, you would get in the habit of doing that because you're always making a record. So everything that you're saying is being typed down or recorded and then typed down later. So you need to make sure that you're making a clear record in the event when you want to appeal or something. And I know that isn't happening here, but if we're preparing to do that eventually in our lives, then why not start now, right? So, you know, that would be my suggestion. Every time you come up, introduce who you are to the court and ask to proceed or whatever. And also, it will help the judges probably too. I didn't get the feathers weight thing.
Oh, like with presumption of evidence, like.
Yeah, I understood that, but I don't know why we, I don't get why
Oh,
we,
you don't like that?
I didn't like that expression personally. But that's just a personal preference, so it's up to you guys.
I mean, other judges have told us, like, you gotta add something extra than just by preponderance of the evidence. which
Well, I
is more
agree,
like
but you
you're not,
can
and add, like,
What about 51%?
okay, yeah,
Like,
It was
what
just-
is a feathers? I don't know. That's just my opinion.
mean-
You can just tell me I'm an idiot, that's fine. And remember to reserve time for rebuttal, because the reason I asked opposing counsel if he had an objection is because you didn't reserve time before you started. So that would be my suggestion, make sure you always reserve time, because when you start getting into this, if you're gonna do the whole season, if you forget to do that, I mean, somebody could very well object, and they should not be able to rebut. You don't have to reserve it now. I would still do it.
How would you say that you would
Just before you start, Ian, I would like to reserve my additional time for rebuttal. Do you do before or after you do your, after you finish?
You can do it before, but yeah,
it's
I
practice.
realize that, yeah, I think it wasn't, like you said, that I know that the new rule doesn't require it, I would just do it just, you know, just because.
I think the other issue is make sure that your witnesses are actually answering your questions. And I don't mean like they didn't answer yes or no like you like, but like, that they're not doing things like or simply because you're asking a leading question, you just assume in your mind that they answered. Because that did happen in some situations. I mean, this witness was really good at being like, If I'm the attorney questioning this witness, I would be like, is that a yes? Or is that a no? What is that? Remember, everything's going on the record. I mean, I know it's not here, but, you know, you think you gotta make a clear record, right? So, what does mean? How's a court reporter gonna type that down?
And good job for a witness on cross who gets away with that.
Yeah,
because
excellent.
That's what you want to try to do, is to try to muddy things up, so that's good.
But, yeah, just, you know, make sure that you're like listening to what they're saying and, you know, they're, you know, that they're actually answering, like with something that's verbal, you know? So, I don't know, I think that's good. Do you guys have any questions for us?
Can we come up to you for individual comments?
Sure. Sure, we'll stick around. We hear there's food downstairs, so don't keep us too long. Thank you.
Yeah, thank you all.
Good job,
Nice
everyone.
job.
Thank you for taking the time, Jeff.
But you put her.
Thank you very much for
Nice job.
I actually wanted to encourage you. I think that you have a really good demeanor personally. Like you have a good swagger and a good like tone and speed of speech. So I to be honest with you, I really want to just like see you.
All right.
Just object that.
Have a really nice.
I just started learning some people.
Is this your first year?
Yeah.
Oh, you're doing great. You have nice presentation style.
I mean, you actually have, you did a good job.
Yeah, you did. Yeah, and you think you won the.
And don't be scared, I mean, about, I mean, like, if you even think that it's like an inkling that's something that's improper, just to check. I mean, but, you know, you should be patient.
Yeah.
Thank
you very much. Thank you.
Well, which school are you guys from?
Norfolk.
We're Northwood.
Okay.
Just getting in early.
Nice to meet you, good job.
Nice
Yeah.
You have to keep together, so, make sure that when you're doing your closing, that you weren't arguing against evidence.
Yeah.
You had like a small problem.
Yeah.
On that, so,